The public defender count, Ms. Cotha Hudson. I want to make it painfully clear that this count has nothing to do with whether Ms. Hudson legitimately or illegitimately failed to appear for court. It has nothing to do with whether she should be disciplined or not because she didn't call the court or didn't appear in court. The premise of this count is that Judge Allred issued the order, which we put into evidence, removing her from 24 criminal cases without notice to her and without any type of due process hearing where she would be given the opportunity to at least explain why she missed court or why perhaps there were mitigating factors where she could continue to serve in her role as conflict counsel for the DPA. We all know that the Public Defender's Office is vastly underfunded, totally understaffed, and absolutely overwhelmed with a caseload. Yet he takes her off sua sponte, without any type of notice, without any type of hearing. That's in total violation of the Due Process Clause, and that's something the judge is keenly trained in. Finally, in terms of the counts, I want to talk about the fundraising. Judge Allred has acknowledged from day one that he committed those particular acts. And again, I don't question the fact that Judge Allred's motive for fundraising for his kids may have been noble. He wasn't trying to feather his own nest. He wasn't trying to put money in his pocket. We've never accused him of that. But he has to recognize that when you engage in that type of conduct as a judge, the person who's receiving that call from the only judge in Harlan County asking for money is going to feel a little bit different than if it's just a parent volunteer calling to ask for money. And that's why the canons restrict that type of conduct. And more importantly, I think this count is very serious. With regard to Kentucky Utilities, he agrees. His response indicates that he filed a complaint with the Public Service Commission against Kentucky Utilities seeking reimbursement for these fuel adjustment charges that have been imposed and assessed against Judge Allred personally and his companies. He contacts and has communication with counsel for Kentucky Utilities and agrees to dismiss the complaint in exchange for a $12,500 contribution. Now again, that's an attorney for Kentucky Utilities who's being asked for a contribution by the sitting judge in Harlan County. How do you think that attorney felt when that request came up? I submit that the solicitation of that donation in exchange for the dismissal of that complaint is only one thing, and it's a shakedown. That's what it amounts to. Judge Allred, in his defense, tries to paint the picture that he was nothing more than a political scapegoat. I think the evidence has shown us here that that simply isn't the case. When he refers to Mr. Johnson as kind of the architect of this grand scheme, that's unfair and it's undeserved. When Mr. Johnson, you heard his press statement when the No True Bill came back, that was played in its entirety. Did he blame Judge Allred? No, he didn't. Did he throw Judge Allred under the bus, so to speak? No, he didn't. He just stated the facts. He stated why it had to be presented to the regular grand jury and why he was doing it. Judge Allred makes a great emphasis, places great emphasis on the fact that Sheriff Lipford talked to at least 3 other people about the Grisham investigation. Don't know whether it's true or not. 3 people say it is. Lippert said it isn't. So what? It's not important in terms of disposing of the charges against Judge Allred. It doesn't matter and doesn't come into play in deciding whether he committed these particular acts and whether he violated the canons or not. He makes places second great emphasis on the fact that Judge Grisham has recanted. Well, I'm not sure he did recant. Gene Weaver told you that he never actually recanted when they spoke to him. When he was questioned yesterday about what happened, he said, yeah, that's kind of what happened in terms of what he said to Gene Weaver, and that lined up, I think, with the affidavit. It was just the line at the end where he said, well, I don't think he actually said he wanted to get control of the property. That's my recollection of what he said in terms of what he wanted to take back. But the statements that he gave in May, which were fresh and which were made close in time to these events, in May of 2010, that I submit is what the truth is. The way he felt, and again, the timing of it all just makes sense. It doesn't take a great deal of logic to do the linkage here. I will say today that I felt that when Judge Allred presented his direct testimony, that he appeared to be rather contrite. And I respect him for that. But as counsel for the commission, I think it's important for the commission to recognize that that is a little bit of a change. If you look at his answer, which I tendered and marked as an exhibit, he flat out and adamantly denied any responsibility or the acceptance of any responsibility for these actions that led to these charges, with the exception of the 2 fundraising counts. In conclusion, I think what the evidence has shown this commission is a pattern of misconduct on the part of Judge Allred covering any number of different events. I think they show that certain actions were taken for political purposes, and that, of course, taints the integrity of the judiciary, affects the entire justice system. These are serious charges, and I think they call for serious consequences.
Thank you, Mr. Mando. The proceedings that have been conducted here the last 2.5 days have been recorded. Judge Allred, if you wish a copy of the transcript of the videos that have been made, if you let Mr. Majors know, that will be provided to you at no charge to you. The transcript, we will have the transcript also. The commission will maintain the original of the recordings for use in preparing our order. As I indicated, under Rule 4.260, we are required to make written findings of fact and conclusions of law, which shall be filed with the record in this case. It is my hope to have that the commission will have accomplished that, as I said, within 2 weeks. That is not a promise, but in the past we've tried to get it done in that period of time. Once this hearing closes, the commission will stay here for a period of time. Whether we will resolve the case today or not, I cannot say, but we will stay here for a period of time to attempt to do that. If not, the commission will reconvene at a time to continue our deliberations. Once the findings of fact conclusions are prepared and entered, they will be forwarded to you, Judge Allred, and to you, Mr. Mando, by Mr. Majors, and they'll be filed with the Supreme Court of Kentucky as part of the record in this case. With that being said, I think it's time for us to close the hearing and then begin our deliberations. But Judge Allred, I see you state.
When you said transcript, are you talking about the entire transcript of this hearing or just a summary of
it? No. There's not a transcript. You'll be given a DVD.
Okay, I want to make sure.
Yeah,
I haven't asked for a transcript.
Yeah, there's not going to be, we don't have a transcript, but the DVD the official record is by DVD. I'm saying DVD, I believe that's what it's on. So you, at your request, Mr. Majors will provide you a copy of that. With that being said, this hearing is now concluded. Thank you.
All rise.